All right, we are now live and recording. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justice of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good afternoon, Council. I'm Justice Englander. Can you identify each of yourselves for the record, please?
Good afternoon, Your Honor. Kaylin Campbell on behalf of the Commonwealth.
Good afternoon, Gordon Spencer on behalf of defendant, Mr. Anthony Howard.
Okay, I can tell you, so this case, this is what was filed as a petition under Chapter 211, Section 3 in the Supreme Judicial Court. It was sent down here for the appeals court to handle and has wound up on my desk. I intend to spend a fair amount of time on it, I think, because I have a lot of questions, and obviously this is a case with a very long history and some important issues associated with it. The case number is 2020J0534, Commonwealth against Howard. It's your motion, Attorney Spencer, so why don't you start off? I will tell you that although I have not read every document in this record, and I doubt I ever will, I've read a lot of your stuff, and you'll find me relatively well educated. So get to the heart of your arguments, and you'll find that I'm going to interrupt a fair amount. Sure.
Judge, this is an issue of constitutional dimension. Obviously, the question is whether or not it's constitutionally permissible to hold Mr. Howard involuntarily without bail for now going on 8 years, and where the delay, and I think this is the primary crux of perhaps what the court might inquire about, is the aspect of the delay and whether or not it's attributable to the Commonwealth. We submit that the majority, pretty much all of it up until about the pandemic, would be in fact attributable to the Commonwealth, and that's about a good 6+ years.
Okay, well, why don't we jump into that, because you're absolutely right. Those are the questions that are on my mind first, is just to understand the fact. So your client is charged in 2013 and immediately goes into pretrial detention, is that right?
Correct, in July of 2013.
And then 14 months to get an indictment? That's correct. And then 3 years later, there's a trial date. Is that the first case? Is that the first time that was a serious trial date?
Hold on 1 second, please. I'm so sorry. I'm at home.
Yeah, so we're all, yeah. Don't worry about it. This goes with the territory these days.
Thank you. Appreciate that.
All
right. So I'm sorry, Judge. What were you saying?
If the dog wants to argue, I'm not sure. But other than that,
he's not as good as me. Trust me.
I'm sure that's true, counsel. So anyway, is 2017 the first serious trial date?
Yes, I can state that he was given a presumptive trial date of 2014. No, I should say 15. I'm sorry. He was indicted and arraigned 2014. It was a presumptive trial date in September of 2015. But with a murder case, we appreciate that cases don't necessarily go to trial within a year. So I'd say the first realistic.
So why? But that's a very long delay for somebody who's in pretrial detention just by itself, 2013 to 2017. Why that delay?
Sure, and my brief really breaks this down. We had a presumptive trial date in September of 2015, and then probably about 7 months before that trial, the Commonwealth represented for the first time. And again, this is about in 2015, 2 years after he was first charged, that they were going to introduce a motive of a gang-related motive. And so what that triggered was about 2 more years of litigation with the Boston Police Department, although I submitted in my papers that the Commonwealth should have foresaw this And so we, in
Well, how
order
could
to,
they not have foreseen this? I mean, they
Good
indicted him in 2014. It took them 14 months to indict him, and they don't know what the motive is yet?
correct. And it was only after Judge Locke specifically inquired of the Commonwealth what was the motive. The Commonwealth said it was going to be gang related, and there was absolutely no discovery produced on that issue. Hence, I filed on behalf of my client a Rule 17 motion because, and again, there's an argument to be made. I don't even think it's necessarily
So I
pertinent.
take it, counsel, you've represented him all along from day one?
That's correct. That's correct. And so we had to go through dealing with the Boston Police Department, although again, if the Commonwealth was saying a gang motive and they
Let
had
me interrupt you again, because
Yeah.
what I may consider important may not be the same thing you do.
Yeah.
Did you at any time file a motion for a speedy trial or for a trial date?
No, because we believe that the discovery was necessary to kind of muscle through before we could even represent that, hey, it's time to get this case to trial. And so we just had to go through that process of getting all the relevant documents that was speaking to the gang motive. And so that's what initially
But
caused.
you didn't even know they were asserting a gang motive for 2 years. Was there any, right?
No,
Okay.
that's correct. That's correct. And I should state that.
So he's in pretrial detention for 2 years. There's a trial date of 2015. What has happened up to that date? For example, was the motion to suppress the CSLI, was that pending during that time?
No, that was filed actually, and I know the Commonwealth will bring this up. That was filed in 2017 after Commonwealth versus White came down in 2000.
Oh, I'm sorry, that's right. White didn't exist until then.
Until
right?
2016. And so we filed in 2017. It wasn't four corners. It didn't require much effort on the part of the Superior Court. And the court ruled relatively quickly on the papers and allowed the motion to suppress. Thereby now we have two areas of delay. The first area of delay is the Commonwealth on the eve of trial, providing the late disclosure of discovery. And then we have the Commonwealth appealing the allowance of Judge Krebs.
You had a September 2017 trial date. When did the Commonwealth produce those 3,000 pages of additional discovery?
July and August.
And I've read Judge Krupp's opinion on that.
Right. And so I was just going to say,
so you folks then filed a motion to dismiss.
That is correct.
And it took nearly a year to rule on that.
Well, May. So we're talking about between September and May. So close to it.
And
going on a year.
In between, you and the co-defendant sought bail. Was that the first time you'd sought bail?
Correct. Right after the discovery dump, both Mr. Christian and Mr. Howard sought to be released on bail. And then we start getting to this disparate.
Why did it take so long to seek bail? 4 years to seek bail?
Well, again, the first realistic trial date was 2017. And
that I have to tell you, as somebody who hasn't practiced criminal law, okay, that's astonishing to me. I mean, you cited me a Second Circuit case that says 14 months of pretrial detention is a federal constitutional violation. The notion that 4 years to get to trial with someone in pretrial detention is somehow acceptable or okay is just foreign to me.
Judge, if I can, and I actually agree, the realistic problem is this is not foreign to the Superior Court. Obviously, the District Court, it would be because murders aren't tried in the District Court. But Superior Court, it's not foreign for a case to take well beyond, let's say, 14, 16 months to get trial ready. And a lot of times,
with someone in pretrial detention?
Yes, I think perhaps Ms. Campbell can attest to this as well. It's just, I hate to say it, it appears to be somewhat of the norm, and quite frankly, I think more motions are probably going to be filed, particularly because of this problem. But it's just a.
But one of the things that I have to think about, right, is whether the decision not to pursue on your part a earlier trial date was tactical.
Oh, no, absolutely not. Because if you look at the actual procedural posture of the case, again, there was years of back and forth discovery with the Boston Police Department. If the Commonwealth produced these records, in support of their gang motive, and it took them, let's say, 3 months or 6 months to produce this trial would have been scheduled long before. We just couldn't answer trial ready without having all the information that the Boston police.
But you didn't know that there was going to be more information forthcoming. You could have said, we're ready for trial, and then put it on the Commonwealth to say, oops, we're sorry, we forgot. We actually want to prove a motive.
Well, that's true, and then this can inure to the detriment of Mr. Howard, but he also has to do his due diligence.
I'm not sure why it would inure to your client's detriment. I mean, if they haven't put the documents out, they're not going to be able to get them into evidence.
No, I understand that. It's just that when you're talking about a gang motive, oftentimes, and in this time, it's also the case, you're going to come across gang evidence that speaks to third-party culpability. So, for example, if you have one gang rivaling with another gang, and then you find out through the discovery, in which we did find out that there were other people that wanted to, from other rival gangs, that wanted to kill the alleged victim, we are entitled to that type of discovery to put on a proper defense.
Let me ask you this: if you prior to 2015, if you said ready for trial, you don't have a strong enough case, we're ready for trial, and then the Commonwealth shows up at trial and starts putting on witnesses who say your guy's a gang member, he had a beef with the people who got shot. Does that evidence come in or not?
I don't think it comes in. So I appreciate the court's point. Back in 2015, when the Commonwealth represented that there was a gang motive, the trial wasn't immediately derailed and moved. We started a process by way of discovery. It was my expectation and hope that by the time we got to September, this disclosure would have been complete. It just kind of spiraled and almost imploded with respect to the amount of information that was being provided as far as discovery on the gang aspect of the case. And I perhaps agree with the court that the first 4 years, I could have been more diligent in pressing the case to trial, but this is a murder case. And so you don't want to
counsel, please don't take from me any aspersions whatsoever, okay? I'm really trying to understand
the delay.
One of the problems with coming to an appellate court with an issue like this is there are 7 years of history. And I need to know enough to render a thoughtful decision. So
we were litigating. That's the best answer that I could provide. I didn't want to jump-start it.
Well, also, I observed that at that point, there was CSLI evidence that had been provided to you that placed your guy near the scene of the shooting at the time, right?
His cell phone. But yes, arguably.
Placed his cell phone. Sorry, correct. My mistake.
That's okay. So that was, but that's been suppressed. And, I think actually
that's been suppressed.
And that speaks to the strength of the case, quite frankly, because when you now whittle it down, the case consists of merely circumstantial evidence, i.e. tying Mr. Howard to the vehicle, but not tying Mr. Howard to the crime scene. I would also add that Mr. Christian's cell phone evidence is still admitted. And so therefore,
really?
Yes, it was Mr. Howard or Mr. Christian didn't have standing to challenge that. And so the evidence I would submit is stronger by way of direct.
Christian didn't have standing to challenge his own cell phone evidence, but Howard did?
No, it's the cell phone evidence was, there was a cell phone seized from Mr. Howard. I think the circumstances behind how the Commonwealth got Mr. Christian's cell phone, if he wasn't indicted until 2 years later. And so I'm not 100% sure as to how the Commonwealth came into possession of his cell phone or his CSLI. I was just kind of focused on Mr. Howard. But
when they tried Christian, it was a mistrial, right? When did that happen?
2019, I want to say.
And the CSLI went into evidence?
I see the nod to yes. I wasn't present for the trial.
Okay. Why did the case mistry?
I can't answer.
That's the jurors.
I second
Ms.
that the trial. It was a hung jury.
Oh.
It hung. Even with the CSLI?
Yes, with the CSLI. I could speak to that. I think the evidence is very different against the two co-defendants. I disagree with my brother's assertion as to Mr. Howard, but Mr. Christian, it's a more circumstantial case against Mr. Christian because it really is his CSLI that puts him with Mr. Howard in the car, whereas there's different evidence that puts Mr. Howard in the car, picking up the car from the rental place. He matches the vague description of one of the individuals in the car at the time of the afternoon homicide, and he is with the car after the homicide.
What's the evidence that ties Christian to Howard that got into evidence during his trial?
They had gang affiliations together through phone records, and the CSLI places them, when you look at the map, at the same points of time at the same. There are two dots that sort of follow the same tracks, which one is Howard's phone and one is Christian's phone.
Did Howard CSLI come into evidence against Christian?
It did.
Their cases are severed.
Okay, I'll tell you what, I think maybe I'm going to switch gears. Well, let's just, you asked, the first request for bail then took place in 2017 or 2018, and it was denied by Judge Krupp, is that right?
On two separate occasions, that's correct. One before his due process or motion to dismiss ruling, and then one after.
And when did he rule the CSLI was out?
That was, I want to say,
October.
yeah, it was definitely
It post-dated the September.
Correct. Once the discovery dump was given, the trial was just taken off the list. And so then Judge Krupp took his time to rule on the motion to dismiss, as well as my four corners.
Another question I have for you is, and I have the set of Vasquez factors, and I'm going to try to make sure I understand how the facts on each of those. But one of the factors that's not in Vasquez, that is in Luigi, is COVID. And your client, based on medical records that I've taken a look at, is a diabetic and has hypertension. Is that correct?
That's correct. He also believes he has lupus, has not been confirmed. He also has hyperlipidemia, and he's extremely obese.
He's extremely obese?
He's about 200, well, it's 260, 5'8" or 9".
And you put in some evidence that hypertension and diabetes are both appear to be
Aggravated.
Aggravators for COVID, right?
Correct.
Or at least higher risk of serious injury if you have COVID and you have those.
That's correct.
And is that the evidence that I looked at was from back in April, when of course I didn't know a whole lot yet. Have those correlations, have they held? Do we have more recent evidence to the same effect?
I don't have any evidence that rebuts it. I haven't done much research on it recently, but I'm pretty confident in stating that those conditions can cause a person to become critically ill if they are infected with the virus. But I could do more research on that.
All right. Well, no, you don't need to do any more research. Did the defendant at any time seek continuances other than the continuance that they sought as a result of the discovery in 2017?
No.
Why did it take so the judge denies the motion to dismiss in May of 2018. Why does it take another year and a half to get a trial date?
The case was stayed due to the Commonwealth's Rule 15 request for interlocutory review of the motion to suppress.
During that time, they sought additional time for briefing. How much of a delay did they seek?
I'd say they filed their notice of appeal in
November of 2017, sorry.
And I think we went to oral argument in March of 2019.
Did you at any time seek to expedite the appeal on the ground that your client was then pretrial detained?
Actually, it was the Commonwealth that represented to Judge Roach that they were going to seek an expedited appeal, but I don't think they ever did.
So the answer to my question is no, you did not.
I did not.
How long did it take the Commonwealth to brief from the time that the case was entered until the time that they got their briefing?
I can say from memory that they did request an extension to file their brief. I think they filed it around perhaps September of 2018, and definitely in that neighborhood. Fall, I think the fall.
Well,
of
if you complain about their delay, counsel, it would be nice if you had an answer to that question.
Sure.
Because I think it's relevant to me.
Well, that is true, Judge. I did file one motion for bail before Judge Roach, and it should be in the pleadings because the counsel sought additional time to get their brief filed, and I know that was filed in August. And but I didn't argue my motion for bail until October, and by that time they had already had their brief filed. So I want to say it was September of 2018 that they filed their brief. I could say that with a pretty high degree of certainty.
So maybe 150 days to file an opening brief with someone in pretrial detention who sought bail more than once, Ms. Campbell?
No, Your Honor. I asked for one extension of 32 days. The case entered in July of 2018, and I'm looking at the appellate docket, and I filed my brief September 14, 2018.
So it took 8 months to get the case docketed. Is that right?
I'm not. That is when it entered. I think there was a problem getting the transcripts of the which
The
was
motion to suppress.
Correct.
So you took a total of 70-something days to file your brief?
I took 32 days.
Well, you took 32 in addition to the 40.
In addition to the 40, yes, so 72 days. The defendant asked for 42 days. He sought an enlargement as well.
So he took 72 days as well to respond?
Correct.
That's correct.
Kind of hard to complain then, isn't it?
I'm sorry?
Isn't it kind of hard to complain then?
Well, not for that period of time that I'm asking for an extension. I'm just complaining because Mr. Howard is just in custody while the Commonwealth is
Right, but it took you until 2017. Now, granted, I understand. Part of the reason for that is White didn't exist. But it took you until 2017 to file the motion to get the CSLI out of the case.
Correct.
Right?
Yes.
You won it. Commonwealth decides to take an appeal as their right. If they just went through the process. Now, the whole thing should have been expedited, but query who should have sought it. And so anyway, that's where we are. I understand what the facts are. Attorney Campbell.
Yes.
Ever seen 7 years before?
I haven't seen 7 years before. This is an unusual case, and the Commonwealth admits that this is an unusual case. I think looking at the docket, there are some things looking at the docket I would like to point out. This case, prior to the defendant's first motion for bail, which was in 2017, the defendant either asked for or agreed with 22 times to continue the case. So I don't think that this is a case in which you can say it's the Commonwealth sort of dragging their feet. There is a history with discovery, but looking at the docket, there is an explicit agreement on the docket at least 22 times of agreeing to continue the case in this instance.
Okay, so I haven't read the docket in that kind of detail. So this is useful to me.
Mm-hmm.
So you say the defendant asked for some of these continuances?
I believe so. Looking at it, it's definitely the continuances are by agreement. I have the docket in front of me, but when you look at it, there's definitely no objection to any of the continuances.
And when are these motions filed? Like, I'm sorry that one of the difficulties with remote argument is simply just being able to get a hold of so I will look at the docket.
Mm-hmm.
And I know that Attorney Spencer is looking at the docket right now, so I'm sure he'll have something to say to me too. But are these 22 continuances prior to 2017?
Yes. All 22. I stopped counting at the point that he asked for the first bail motion. And so I think I don't think it's fair to look at that time. If you were looking at it in a speedy trial context, you wouldn't count that time for purposes of speedy trial because there is an express agreement as to the continuance in that case. I'd also say if you're doing a speedy trial type analysis, certainly the defendant during this time period is filing multiple motions. All of the discovery in this case, and I think this is important because if you look at the last time that the defendant filed this motion for bail, it was in front of Judge Roach. Judge Roach not only was the presiding judge of the co-defendant Rashim Christian's trial, but she also is the regional administrative judge in the homicide session. So she is very familiar with Mr. Howard's case. She's very familiar with the motion and the findings that she makes. She talks about the delay and the reasons for the delay and the motion to dismiss. So these are certainly factors that Judge Roach considered. I disagree with my brothers. He opened by saying the question for your honor to answer is whether this violates due process. I think if you look at the case law, the question that you have to answer is whether the judge, in this case Judge Roach, abused her discretion in denying the defendant's motion for bail. I disagree as to what due process entitles in this case. Due process, at least under Massachusetts law, which I would say your honor is bound by, is—
I'm bound by federal law too, counsel.
You are, but I would say—
Which you did not address in your opposition. You did not address his federal cases. You chose not to. I do not know why that is, because federal due process applies.
Sure, federal due process does apply. What any concept of due process gives you, though, is the right to a hearing. And the defendant—
No, I disagree. I'm sorry, counsel. We're going to both learn some law, I think, because I'm very concerned about this. I saw your argument. I've heard exactly the same arguments made by others. It strikes me as just flat out wrong. Due process allows him a right to be heard in a meaningful time and in a meaningful manner. That's the basic fundamental right. And that fundamental right means that when you're charged with something, you don't sit for 7 years incarcerated without being adjudicated to have been convicted. And any notion otherwise just cannot be consistent with due process. It is not due process to say, I will continue to give you hearings as to whether we can hold you pre-trial indefinitely, which is what you argued to me in your brief, right?
Absolutely, and I'd say that—
How can it be a hearing in a meaningful time and a meaningful manner without getting a trial to adjudicate whether in fact you committed the crime?
Certainly, Your Honor, and I would say he had a trial date that was set due to the exigent circumstances.
When you say certainly, do you still disagree with me about what the fundamental law is? Because I mean, I've read all the cases you cite, and they all say at some point due process kicks in a substantive manner.
Certainly.
Okay.
I think here, though, and I wouldn't disagree as to a charge, certainly a concept of due process that would hold you indefinitely. I would agree there comes a point where you would have to be released.
Is that before 7 years?
And in a first degree murder case, with the factors that we have here, with the defendant's record, with the real threat that he would—
You haven't adjudicated. You can't tell me I will be able to prove him guilty, therefore I can keep him indefinitely in pretrial detention.
And I would disagree with that. If you look at cases, I think if you look at Lugie, they cite— it's in a different context, but they cite cases where pretrial who have become incompetent. And they say there comes a point where you have to address whether they will ever achieve competency. And so what you need to have is a hearing to determine whether their detention is unreasonable.
Now, Lugie also says there's some point at which due process comes along and says you can't hold the person any longer, period. But we haven't reached that point. That's literally the ending of the opinion.
It does, but if you look at what Lugie specifically is talking about, it's talking about 58A, which is a different statute, which in the statutory language itself has a definite time.
Cites the problem of the sex offender that was addressed in another one of the cases. I can't remember what it was. Who's in an involuntary commitment, civil commitment context where they had exactly the same thing. I mean, you know, this is so fundamental. It is hard to imagine many things that are more fundamental. We don't hold people without charging them. We don't hold people without trying them.
And Your Honor, the defendant, but for COVID, and I think that's really what needs to be addressed. I mean, in the past 14 months, he has been given 3 separate bail hearings. And I think that the due process entitled him to those hearings, but also what Judge Roach has is the institutionalized history of the past 7 years. She also has a unique view of the case, having seen the case against the defendant. So the strength of the Commonwealth's case, which is a strong case. But she also has in front of her—
You think this is a strong case?
I do, Your Honor.
It's entirely circumstantial. The CSLI evidence is out. His co-defendant, who was tried with Howard's CSLI evidence, had a hung jury. This is a strong case?
Yes, it is, Your Honor. It is a strong case.
There's no confession. There's no eyewitness.
Judge, if the case was so strong, I would say it should have been tried a whole lot sooner. Let's say, for example, it was on video. They would have dumped 3,000 pages on the defendant the night before. They wouldn't have appealed the CSLI. I think that the case is—
Counsel, if you will, I understand your point. Okay. I think I need to go one at a time. And Ms. Campbell, I think she knows this, but I'm being tough on her. But she's also one of the most senior appellate lawyers in the Commonwealth, and she knows this stuff, and I know she can take it. And I want to make sure that we go through all of this so that I understand what the Commonwealth's position is.
Sure.
Okay.
Absolutely, Your Honor. But what we're dealing with here, and I make no representations that this is a typical or usual or ordinary case. But I don't think that takes away the discretion of a judge to look at the factors as set out in Vasquez. And what Judge Roach did, you would have to find it amounted to an abuse of discretion, which would be outside the reasonable range of alternatives. And I think when you look at the Vasquez factors themselves, specifically the risk of flight, given that this defendant is facing, if he is convicted, a mandatory life without the possibility of parole sentence. But not only that, the defendant's, both his border probation record and his institutionalized history, in which he has countless D reports. What really, if you're looking at, I think—
Let's leave aside for a moment, because I'll get to it, but I'm going to have to confess one flaw in my preparation when I do. But let's start with risk of flight, as opposed to the information that indicates that he's a dangerous person.
Sure.
Okay? Because I think they're 2 different things. All right? What's the evidence that you would point me to indicate that he's a flight risk?
So first, I'll start with Vasquez recognizes that the charge of first-degree murder is different than all other charges. So inherent in that charge is an increased rate of flight of risk. But not only that, if you look at the defendant's border probation record, which has 26 adult entries, what you'll see is he's defaulted 9 times, which is a factor that certainly should be
Attorney
considered.
Spencer says every single one of those was a technical default because he was actually incarcerated at the time. Now, I didn't find all 9 of them. I found a number of them that were like a day or 2 days of default. What do you say to that?
And I would say that any default is a default that you can look at. I think also telling
well,
is—
but not if he's incarcerated and the jail people just don't get him to the courtroom.
That is true, but I think it's also important if you look at the times that he has been on probation, which conditions have been set, which is a court order, he's violated, if you look at his record, almost every single time. Not only violated.
How many probation violations? I saw several. How many are there?
I didn't count the number. So there's one from 2011. There's another from 2010. So that's 2. There's another from 2008. There's another from 2006. He violated also in 2005, again in 2004.
So there are half a dozen probation violations.
And again, yeah, there were 2 separate ones in 2004, I believe.
Now, what would you point me to in his adult history, actually in his entire history, because I read most of the juvenile history as well, that indicates that he's a dangerous person? I saw arraignments for assault and battery. I saw no convictions. In fact, I saw no convictions for violent crime.
Certainly,
is that right?
That is correct. I would point, admittedly, to the facts of this crime, the brazen nature of 2 shootings in one day. And not only 2 shootings in one day, but the afternoon homicide happened. It was a nice afternoon in June. There was a family that was having a barbecue right near where the shots were fired into the car. So the brazen nature and circumstances of the crime itself, which Vasquez says can be indicative of the danger posed, is what I point to. Also, I would point to, though, the defendant's disciplinary history while incarcerated.
So here comes my confession.
Yeah.
I have not been able to review the disciplinary history in jail. I will. So what you can do is summarize for me what you think it shows, and then I'll ask Attorney Spencer whether he agrees with your summary or not. I will tell you that I'm not sure how important it is. It seems like the Commonwealth pulling itself up by its bootstraps. Look, we've had him charged, but we couldn't try him for 7 years. But in the meantime, turns out in jail he's a bad guy, so you ought to leave him there.
Well, no, I disagree with that, and I think that they are indicative. What any judge doing when you're looking at the setting of bail or the ability of set bail is the reasonable assurances that this individual will come back to the court. I think looking at his ability to follow rules both outside of an institution and inside of an institution is important to that analysis. And a continued here, if you look, there are a number of violent incidents. The last happened in 2018, so that's 2 years ago, but it's continued. If you look at the names, they are names that come up in this case. He gets into violent altercations with alleged gang members. One is specifically with Julian Printemps, who is one of he shot at in the morning in this associated case. So there's this continued not only animosity but violence of a gang nature, which I think is important.
What are they, fights?
There are a number of fights.
Involve weapons?
There are a number of fights. There's one incident where he picks up a trash barrel and attempts to hit somebody with it, is unsuccessful. He's thwarted before he's able to. But I don't think it's bootstrapping. I think it's just further evidence of an inability to conform with rules, which is a necessary component of considering whether there are conditions that will be placed upon this individual to reasonably assure his appearance back in court. As to the violence,
how many fights?
I didn't.
I take it he hasn't been charged for any of these separately.
He hasn't. You know, I didn't tally them. There's at least 5. I think if you look, I did representative examples in the Commonwealth's pleading, so I could count the sites I did, which didn't encompass all of them. They just encompassed some of what I thought were the most telling. But 1, 2, 3, 4, 5, 6, 7, 8, 9. So at least 9. But I really think
the last one of which was 2 years ago.
The last one of which was 2 years ago. He has D reports from this summer. I didn't pull any more recent ones because the question is confined to the sort of material that was before Judge Roach. But this summer there was continued. This is less minor, but I think indicative of an inability to follow rules. What the jail described as a scheme to steal other people's free phone calls. He was told not to do it. He continued to do it at least 2 times after that. So again, it's a failure to abide by conditions that are placed upon him, which I would say is relevant and necessary for bail determination.
What do you do with the fact that he has conditions which, do you agree that he has the conditions that have been represented, hypertension and diabetes?
I have seen medical documentation of that.
But you don't claim that he doesn't have.
We don't claim, I don't claim that he doesn't have that. And I think post the SJC's case this week in Nash, that those representations are to be taken and considered by the court. So so I'm not disputing them.
What do I do with that? I mean, what do we do with Nash, right? I mean, wow. if those folks have to be cut loose after they've been convicted, we've got somebody in pretrial detention here. And we have COVID as high as it's ever been.
Certainly, that I can't state other than yes, that is the condition of what we are faced with right now. But I would say that, you know, looking at this defendant's record, specifically the history of this case, that you cannot say that Judge Roach acted outside the reasonable range of alternatives in her bail determination.
Wow. I mean, I just read a case where two of my colleagues were overturned, held to have abused their discretion when they didn't cut somebody loose when they'd already been convicted and it was on a first appeal.
I understand
and
that.
Neither one of those, I don't think, had the same kind of, I can't remember whether Nash did, sort of indicators of high risk with respect to COVID that we have here.
Elibert, the companion case, Elibert, that was a Suffolk County case. I know that he did. He certainly did. I would say that the convictions that they were facing, though, were not murder cases, so they weren't. They don't have the same sort of.
I agree with you.
Of likelihood
I agree.
of possibility of parole. So that certainly is a factor to consider as well.
Although, at least in one of those instances, the crime was quite serious and one that you would be concerned about releasing that person into the community. It was rape, if I recall.
It was charged rape. I believe, I'm not sure as to Nash, as to Mr. Elibert, he was ultimately convicted of indecent assault and battery.
No,
so
Nash was convicted of rape, I believe, of stepdaughter or someone in the household. That's but I may have it wrong. I'm sorry. If you give this person an ankle bracelet and go 6 to 6 in curfew like they did with his co-defendant, tell me why that's a bad result. I'm not actually, I don't see myself imposing any such conditions, but I want to understand what the Commonwealth's position is.
Certainly. The 6 to 6, if it's really releasing him, I believe that there have been conditions that have been placed which are home confinement, except for work and medical appointments. I believe if that were to be imposed in this case, that would be a sufficient condition.
Home confinement.
Correct.
With a bracelet.
With a bracelet, given the defendant's history, both in the prison and his history with defaults and violating probation.
What I'm hearing, sort of trying to distill it, is that the first 4 years were as much an issue with the defendant as they were an issue with the Commonwealth. 22 continuances agreed to, no requests for trial dates. And at that time, there was CSLI, which placed the defendant near the scene of the crime, in addition to all the evidence about the car. But there's been a changed circumstance since then, which is the CSLI is out. Just somebody fill me in on what the thinking of that was, that the Commonwealth's affidavit was inadequate to identify why it was that it needed Howard's CSLI?
No, so it's more convoluted than that. It was a motion to suppress a cell phone. When he was arrested, he had a number of cell phones. We got a search warrant for the cell phone, and it was that the search warrant for the cell phone was too broad. The problem here is the only way we got the number to get the CSLI was through the search of the cell phone. So if you lose the search of the cell phone, you lose the number.
The search of the cell phone violated White.
Correct.
When you searched the cell phone, you got the number for another cell phone? which is the cell phone that was actually in the car?
No, we got the number for that phone.
So you couldn't get the CSLI until you opened up the phone and got its number.
Yes.
And the court held that you were not, under White, allowed to get the number of the cell phone in order to check his CSLI, given all the other evidence you had against him at the time.
Correct.
Well, Mr. Spencer, I think you've done a good job for your client. Did you argue Andrew? You argued Andrew, didn't you, Ms. Campbell?
Andrew?
Yeah, in the appeals court?
I did not. Are you thinking of Arthur?
Arthur. You
Yes.
argued Arthur.
I argued
Yeah.
Arthur, yes.
It was 6 letters starting with A. Yeah. Okay. Wow. But after the document dump, which I haven't heard you try to defend, and it sounds like it's extremely difficult to defend, there's a request for bail, and we're still another 2 years before we get the case to trial.
Yes.
So let me look at my notes. What do you say about his institutional disciplinary record, counsel?
Judge, that's a very interesting issue. I've never really come across a bail argument that brings up institutional records. I would state, and this is just from my interaction with Mr. Howard, that over the years, and understandably so, has caused him a considerable amount of stress. And I would submit that how a person behaves in jail due to the fact that they're stressed out because they're held COVID, they're debilitated, because all of the illnesses that he's incurred, he's been diagnosed after he's been in custody. This gentleman, I believe, is only 34 years of age, and he's—
That justifies getting in 9 fights while he's in jail?
No, not at all. But, and perhaps the court and the Commonwealth—
Is she right that that's what I'm going to find when I look at the record, at least 9 fights?
I don't think it's going to be that many fights, but what you are going to see is that, and this is just an institutional problem. When you have people from different parts of the city that are—
You have gang members from rival gangs, one of whom apparently shot at the other one, or at least that's what's alleged.
Right. There's going to, I mean, fights, and I hate to say this, but they're just inevitable. And it doesn't necessarily mean that Anthony Howard was the fire starter. They're both, usually my experience has been, when they get into fights, they're both sent to the hole, so to speak. They're both punished without regard with respect to who started the fight. And I don't think getting yourself into trouble in jail is a strong indicator that means that if you're given a court order and you're told to stay at home and keep the bracelet on, he says, well, you know, I fought in jail, so I'm just not going to abide by this court order where I'm being given the opportunity to be home with my family. I would think that any person would be very grateful for that opportunity. And I can't imagine they would be getting into fights while in the home, especially on home.
Tell me about his family. Does he have one?
He does. His grandmother, who's really the primary person in his life. She's been to every court date. He lives at home with her. She lives alone. And he has also a daughter, and he has a mother, but the mother's been through a rough ride, some mental health problems. And so, but his father—
where does he live? Dorchester?
Dorchester, yeah. Normandy Street, right off of Seaver. And so the grandmother owns the home. He's been a resident there for most of his life. And he has roots in the community, quite frankly. I don't—
He was 27 at the time of the incident, is that right?
That is correct. And another thing I'll add about
He
is
has no employment history whatsoever.
no employment history.
Never paid a tax, apparently.
Like a lot of my other clients, yes, never paid a tax. I don't see the correlation between risk of flight. It just means, actually what it means is that you don't have a lot of resources. And he doesn't, obviously being in jail for 7 years. And so I think
it means you don't have ties to the community. That's literally that's an element that's in the case law, employment history.
No, it's true.
Because employment history gives you ties to the community. It gives you a reason to stay there. It gives you a reason to be there.
No, that's
and he doesn't have that.
True. I would encounter that a person could leave and get a job with false identity anywhere. And so because if a person's looking at a murder sentence, I think the fact that they have an employment history is not really going to speak to issues of flight. If they want to run because they don't want to spend the rest of their life in jail, they're going to run, notwithstanding their employment history. So as far as just those factors, I would just say, and the only thing I would add is that Mr. Howard and I thought this was a very compelling reason. I brought in front of Judge Roach that because of his illnesses, that he would be willing to allow law enforcement real-time access. And there's a CFR that I cited to that allows law enforcement to do this, real access to his medical records. So therefore, he needs daily injections of insulin. He needs constant medication. He also
I saw that in the footnote. I thought that was an interesting point.
He has an
I'm gonna give you each an opportunity to tell me whatever it is that you think I should hear, and then we'll be done with the hearing. So starting with you, Mr. Spencer, anything more you think I should hear?
Sure. My brief is 60 pages, so I think anything I say would be redundant. But I would highlight, because I think it's very important. Count says no due process violation. Count versus GF, we have a situation where a person had 3 mistrials and other delay, and the court held that there was in fact a substantive due process violation after 7 years. And so where a person doesn't have one trial, I just don't see how anybody can come to the conclusion that due process is not particularly offended. And I think the problem really began in 2017, where you have direct evidence of Mr. Christian due process violation. He gets a remedy and Mr. Howard doesn't. And the only reason seems to be the strength of the case. And the only thing I'll end on is that I think the strength of the case is a statutory bail factor, but I think you get to that point after you address the due process. So he says, okay, well, he's entitled to a bail. And then you go through issues of risk of flight and whatnot, and you set a bail under Brangen. But it just seems now he's saying, no, strength of the case means you don't get a bail. And that sends the message to the Commonwealth that the case they perceive to be strong, they can proceed at a snail's pace, or they can take different steps that can cause a delay
not that the Commonwealth perceives to be strong, the case that is objectively strong.
Objectively strong.
In that instance, the courts are going to be more hesitant to let somebody out who's facing life without possibility of parole against a strong case.
Understood. But Claudio Gonzalez, and I think that's a very, very important case. I did cite to a lot of factual nuances in the case, but that case stands for the proposition that at some point in time, the risk that society has, or that the interest that society has in bringing a person to trial gets outweighed, meaning that they have their interest to get this person to trial. They don't want them to flee, but that gets outweighed at some point by the 14th Amendment. And so I would just rest on my pleadings.
Ms. Campbell, before you tell me what you want to tell me, what's wrong with what he just said? You tried to tell me that that wasn't Massachusetts law, and I cut you off in the middle because I think I'm bound by the federal Constitution as well.
Sure. I think I disagree, and I can't pull it up, and I don't want to speak out of turn as to the specific factual scenario presented in GF, but I think
no, not GF, no, Claudio Gonzalez, 14 months, Second Circuit, John O. Newman. That's a good panel, okay? Mm-hmm. Now, I understand that it would be extraordinarily difficult to say that the law is that after 14 months, you got to kick people loose. I'm not suggesting that in any way, shape, or form, but those are the facts of that case.
They are. And I would say here what you have is, you know, a very experienced judge who knows the whole history, who considered all of the factors that Mr. Attorney Spencer just laid out, who had the benefit of knowing the case in and out, who had the benefit of looking at Mr. Howard's record and making the determination that she did. Again, what is critical is the very purposes of conditions that are set for release and whether any of them can reasonably assure the defendant's appearance back there. And, you know, there's certainly the interplay between due process. Certainly, I hear the concern and I absolutely hear the concern, but I think that just putting a bright line rule or saying this is 14 months or not 14 months without considering the history of this case.
Yeah. I'm not suggesting a bright line rule, nor will I suggest a bright line rule. 7 years is astonishing. Even with the first 4 years being perhaps not to be laid at the Commonwealth's feet.
Your Honor, and I would say once we decided to take the appeal, it took from, we argued the case in March, it took from March to September when the decision was issued, and then it took, we applied for FAR, and it took until February of 2012 for FAR. So certainly, and those were all could be considered changed circumstances in order for Mr. Howard to try to get bail.
Well, no, he was trying to get bail starting in 2017. As soon as the Commonwealth did a dump and he couldn't go to trial in 2017, he said, just like his co-defendant did, time to let me out. This is your fault. I should have been tried. I wasn't tried. It's your fault. Time to let me out. And the Commonwealth opposed it.
We did.
Okay. Now, at that time, the CSLI still hadn't been, no, the CSLI had been suppressed or was suppressed right around that time. Now, the Commonwealth may have thought that was wrong. Okay. You've both been extremely helpful. I will move with as much speed as I'm capable of to give you a result and take it under advisement. Thank you very much, both of you.
Thank you.
Thank you.